Thank you all so much for coming to join us virtually at Melbourne Law School for the Obligations Group Conference on Unjust Enrichment and Restitution Law for 2020. What a year it's been. Michael and I would like to welcome you, but before I do so, we should have, of course, acknowledge country first. I'm speaking to you from Perth, from the beautiful lands, the traditional lands of the Whadjuk Noongar people, and I'd like to pay my respects to their elders past, present and emerging. Michael, would you like to do the
I'm
honours?
speaking from Melbourne, and Melbourne at the university is situated on the land of the Wurundjeri people, and we pay our respects to their elders past, present and emerging.
Lovely, thank you. Well, we're going to start this year's conference with a panel session, which is lovely. This year we had published, and I happen to have here handy a copy of this fabulous work, Unjust Enrichment Restitution Handbook, which was edited by me, Kit Barker and Swan Degling. Of course, with things turning out as they did, there was little chance for a book launch this year. And so we're very, very grateful that we have a group of panelists who are prepared to discuss the book and to give us their thoughts on its merits and also the areas of it that no doubt need further work and exploration. So very happily, we have for you three terrific speakers to introduce the book and discuss it. Firstly, we will start with Felicity Maher. Felicity Maher is a colleague of mine here at UWA. She's the director of the Private and Commercial Law Research Cluster, formerly the Obligations Hub, but the Private and Commercial Law Research Cluster. Dr. Felicity Maher is a graduate of Oxford. She's also a barrister at Quayside Chambers, and I really thank her for being involved. Rebecca Lee will be giving her thoughts second. She's an associate professor at the Faculty of Law at the University of Hong Kong. She's a long-time friend of the Obligations Group and of this conference. She works in the area of equity and trusts and not-profit law and aspects in Chinese law, and we really look forward to her thoughts on the book. Finally, we are honoured to have Dr. Michael Rush QC join us today. He is at the Victorian Bar, and of course he is the author of the very good monograph on the passing on defence. So thank you to all for joining us, and I will now turn over to Felicity, who will start proceedings going. And Connor, you can take it over from here.
Well, thank you, Elise. And I'd like to begin by congratulating the editors of and all of the contributors to the research handbook on unjust enrichment and restitution for what is, in the words of Justice James Edelman, who wrote the foreword, a stunning achievement. The editors, Professors Elise Bant, Kit Barker and Simone Degerling, set for themselves the task of bringing together leading scholars from around the world to develop an architecture for the law of unjust enrichment. And the result, I think, is a huge contribution to this area of the law and a really important step towards greater clarity and coherence. In the time that's been allocated to me this morning, there are three things I would like to do. The first is to give a very brief overview of the handbook for the benefit of those who are yet to lay their hands on it. The second is to make some comments on the handbook from a practitioner's perspective. And the third is to make some brief observations on some of the key themes or big questions which seem to me to emerge from the handbook. Rebecca and Michael will then descend into a bit more detail with a focus on some particular chapters. So just starting with the overview then, 28 leading scholars from various common law, civilian and mixed systems contributed to the handbook. And as a result, the approach of the book is pan-jurisdictional, which I think is one of its strengths. There are 24 chapters arranged into 6 parts. The first part really sets the scene, considering the historical context and offering some comparative insights. Second part, consisting of 5 chapters, engages with the problem of taxonomy. The third part, with 4 chapters, then addresses the philosophical foundations of the subject. The fourth part, perhaps the heart of the book, with 7 chapters, then dissects the analytical structure of unjust enrichment. The fifth part, with 3 chapters, then examines defences, and the 6th and final part, with 2 chapters, considers restitutionary remedies. So the sweep of the handbook is broad, it's ambitious, it takes in those historical and comparative perspectives, and then moves from philosophy to principle and practice. I mentioned practice and the practitioner's perspective because although I do still like to think of myself as an unjust enrichment scholar, having completed my PhD with Professors Burks and Burrows, I now spend most of my time in practice as a barrister, as Elise mentioned. And what I've really noticed among practitioners, including many judges, is that the law of unjust enrichment is viewed with some suspicion, even fear. I thought that I would share with you some comments, entirely unprompted, overheard in the corridors of Quayside Chambers earlier this year. The law of unjust enrichment, it was said, is a choose your own adventure. It's a mess. It is as if no one ever sat down to work out how this can be used by practitioners. Well, plainly, my colleagues hadn't seen the handbook. I think that one of the great strengths of the handbook will be its usefulness to practitioners. And that's particularly so in relation to the 4th part on the analytical structure of unjust enrichment. I think the chapters in this part do 2 main things, which will make the law of unjust enrichment a more manageable tool in the hands of lawyers and judges. The first thing is that they identify and confirm the structure of claims in unjust enrichment. And an understanding of this is of fundamental importance when it comes to one of the first and most basic tasks of a practitioner confronted with a claim in unjust enrichment. How do I plead it? And in my experience, it's still a real stumbling block for many practitioners, and it's not uncommon still to see pleadings falling back on the old language of the forms of action. The second thing I think the handbook does, which will assist practitioners, is to give really detailed consideration to each of the elements of the analytical structure of unjust enrichment, enrichment at the expense of, and unjust. For example, Professor Mitchell McInnes's chapter on enrichment is, I think, a really accessible analysis of the various functions which this element of claims in unjust enrichment serves. And the same can be said about Stephen Watterson's comprehensive chapter on the at the expense of element. It's fair to say that this element is perhaps the most overlooked in practice, but a really striking feature of Stephen Watterson's chapter is its elucidation of the very large amount of work which this element does. The 5 chapters which follow then usefully examine various aspects of the unjust element. And to mention just one of the contributions, the chapter on the impaired intention unjust factors by Professor Mindy Chan Wishart and Rory Gregson provides quite a practical overview of the key principles informing some of the reasons for restitution which crop up most frequently in practice, principally mistake, of course, but also duress and undue influence. It's my view that each of the chapters in this part will become a ready reference point for lawyers and judges alike as they seek to identify and resolve the issues to which a claim in unjust enrichment gives rise. Finally, I offer just a few observations about some of the key themes or big questions which emerge from the handbook. Justice Edelman in his foreword and the editors in their introductory chapter identify several of these themes, among them the unity or disunity of this subject, how to avoid too much restitution, relatedly, the relationships between unjust enrichment and other areas of the law, as well as the tension between a rule-based approach and a discretionary approach to unjust enrichment. I'm going to touch on the first of those, but then just suggest a few others. I think perhaps the fundamental question about the law of unjust enrichment, which crops up again and again across the chapters of the handbook, is the extent to which the subject is or even can be unified. The story of the law of unjust enrichment, at least in common law jurisdictions, is one of disunity to hard-won unity, and now potentially again to increasing disunity in the face of a new wave of scepticism regarding its status as a category of law. The leading skeptics, Professors Robert Stevens and Lionel Smith, aren't contributors to the handbook, but their views are certainly referenced repeatedly. Seems to me that this debate about unity arises at several levels. The most granular level, there's argument about the unity or otherwise of the unjust element of a claim in unjust enrichment. For example, Professor Mindy Chen Wishart and Rory Gregson grapple with this issue in their chapter on the impaired intention unjust factors, and they argue forcefully that although the plaintiff's impaired intention triggers restitution, other factors determine the size and the shape of these unjust factors. So a focus on the impaired intention of the plaintiff can only take us so far in our search for the reason for restitution. And likewise, Professor Charles Mitchell deals with the same issue in his chapter on the so-called policy-motivated or policy-based unjust factors. And the reason for restitution in these cases has nothing to do with the impaired intention of the plaintiff. So some real questions do arise about their place within the law of unjust enrichment. At a more general level, in Australia, the High Court has since at least 2001 insisted that unjust enrichment is not a cause of action, it's not a principle capable of direct application. Instead, an emerging view, exemplified by Justice Edelman as a Justice of the Supreme Court of WA in the Lamson case, is that it's not a single cause of action, but a category of causes of action, just as tort is not a cause of action, but a category of causes of action. This approach isn't directly considered in the handbook, but it is subsumed within the discussion of the most general level at which this debate about unity arises. And as to that, the latest wave of scepticism suggests that unjust enrichment doesn't even qualify as a category of causes of action. Instead, what's argued is that claims in unjust enrichment should be understood to arise in several different categories of law. And various contributors to the handbook confront this argument, and I won't attempt to summarise their views, but what is clear is that this is a debate which is set to rage for years to come. Very briefly then, just to touch on 4 other key themes or big questions in the law of unjust enrichment which emerge from the handbook. One is the apparent competition between the common law unjust factors approach to unjust enrichment and the civilian absence of basis approach. And Professor Burke-Hacker deals masterfully with this issue in her chapter. Professor Hacker's key argument is that despite the apparent differences between these approaches, in practice, they usually arrive at the same result. So the approaches are much closer than they appear, the differences being in emphasis rather than substance. Indeed, as the editors in their introductory chapter and some of the other contributors note, perhaps the best advice to practitioners today is to plead both an unjust factor and the absence of any juristic reason for the defendant to retain the enrichment. Another question which emerges from various chapters of the handbook is whether the law of unjust enrichment takes an objective approach or a subjective approach or both. We're all familiar with the objective theory of contract law, but it seems that there is no such overarching theory in the law of unjust enrichment. Sometimes a subjective approach is called for example, when deciding when the defendant was actually enriched or the plaintiff was actually mistaken. But at other times, it's objective, for example, when assigning a value to the defendant's enrichment. It seems to me that the justifications for these different approaches might require some further analysis. Further big question, which emerges from the handbook, is whether a legal or a factual analysis, or again, both, is appropriate when considering issues such as whether the defendant was enriched or the basis for a particular transfer for the unjust factor failure of basis. For example, if a defendant's had the use of property but never held the legal title, has she been enriched? And is the basis for the plaintiff's transfer, let's say pursuant to a defective contract, better viewed as her assumed legal obligation to make the transfer, or her expectation that she'd receive some counter-performance in fact? Finally, an insistent theme, I think, across the handbook is the influence of scholarship in the development of this area of the law. And to mention just one of many giants, Professor Peter Burke's, there are few chapters in the handbook which don't engage with some argument made by Professor Burke's. I could go on, but my time is up. In summary, the editors of and the contributors to the handbook are to be congratulated. I think the handbook makes a major contribution to an area of the law in which nonetheless there remains much to be said. Thanks.
Fabulous. Thank you very much, Felicity. We now would like to welcome Rebecca Lee to speak. And Rebecca, over to you.
Thank you very much. Thank you very much, Elise and Michael, for the opportunity to review this wonderful collection. I must begin also by congratulating Edward Elgott and the editorial team for publishing this very, very thought-provoking collection. The collection provides very rigorous and in-depth discussions of unjust enrichment and restitution concepts from different perspectives, and the issues that have been addressed are significant and difficult. And I fear that I'm only qualified to comment on some of them. So given my interest in equity and trust, I'll focus particularly on the relationship between equity and unjust enrichment as addressed in the parts on history, taxonomy, and remedies of this collection. So let me share my slides with you. All right, so part one of the collection comprises chapters by David Abelson and James Godley on the development of unjust enrichment concepts from historical and comparative perspectives. Abelson's chapter offers a masterly account of the historical development of unjust enrichment at common law, beginning with the forms of action before Lord Mansfield and concluding in the House of Lords judgment in Lipkin Gorman in 1991. So in the 16th century, medieval courts created a new form of actions of assumpsit, court indebitatus assumpsit, and to justify such an extension of assumpsit to cases involving non-contractual claims, the law would imply the promise to show that the defendant received money on the plaintiff's account. The references to quasi-contract, just a product of judicial innovation to extend the reach of this new forms of action. Then came Moses and Macfarlane, where Lord Mansfield attempted to throw off the contractual shackles of the action of a sunset. So Lord Mansfield spoke of an action to recover money according to equity and good conscience, and pointed out that references to quasi-contract was only necessary to give the cases a contractual cloak to justify the use of this new form of action. So I think Abelson's chapter raises very, very interesting questions as to equity's contribution to the law of unjust enrichment and lessons of this historical exposition for Australia. So in the old days, medieval lawyers were generally unconcerned about whether actions to recover money could be rationalized by some unifying principle or an independent legal discipline. So this emphasis on procedure suppressed the development of principles. So given Lord Mansfield's opaque language, on the one hand, some people suggested that Moses and Macfarlane adopted an unjust enrichment approach. On the other hand, judges such as Justice Gama would rely on Moses and Macfarlane to justify the equitable nature of money hadn't received. Abelson's chapter does not provide a direct answer to these questions, but it probably suggests that Moses and Macfarlane does not provide an equivocal support for either proposition. So it is unlikely that Moses and Macfarlane adopted an unjust enrichment approach. So from the history and the developments of the action for money hadn't received presented in Abelson's chapter, Moses and Macfarlane is significant because Lord Mansfield generalized liability to avoid the implied contract theory, rather than his supposed acceptance of the unjust enrichment framework. And indeed, if we look at Abelson's chapter, he goes on to discuss how American legal historians play an important role in identifying a general category of unjust enrichment, and how English academics such as Peter Burks identified unjust enrichment as an analytical principle underlying the subject, thus revealing its existence, the existence of this principle of unjust enrichment as an organizing category. So that's one theme that Felicity has pointed out earlier. Notwithstanding Justice Gama's enthusiasm in Moses and Macfarlane, Abelson shows clearly that mere references to injustice in Moses and Macfarlane is not sufficient to show that money hadn't received had its roots in equity. If that's the case, so the next question that we may ask is the implications of this historical exposition for Australia. So instead of developing an unjust enrichment analysis, Australian courts in cases such as Rossborough, Hills Industries have generalized liability with reference to unconscionability, emphasizing the equitable nature of money hadn't received. So I think a few points should be cautioned. First, unconscionability should not be used as a legal principle to impose liability directly, for otherwise there is a risk of overextension of the principle. So that's another theme that Felicity has touched on that has been confronted in this collection. So I think reference can be made to the recent wave of judicial retreat and academic skepticism towards the subject of unjust enrichment in the United States, in the United Kingdom, sorry. So Lord Reid, for example, has cautioned the reach of unjust enrichment and narrowed the scope of recovery in cases such as investment trusts, companies, and prudential assurance. And likewise, academics such as Rob Stevens, Lionel Smith have questioned the Bursian unifying model in favor of more refined categories and analysis. But notwithstanding this recent judicial retreat, this should not be taken as a rejection of unjust enrichment as an organizing category. The UK Supreme Court remains very firm in endorsing a unifying framework of unjust enrichment. So I think what we need to avoid is probably just a literal application of the four-stage inquiry, and coupled with a continued exploration of the normative foundation of unjust enrichment. I think the prospects of unjust enrichment as an organizing framework, as an organizing category, will continue to be very healthy. The other point that I think we might want to bear in mind is what has been mentioned in Andrew Cole's chapter, which is contained in part 2 of the collection on taxonomy. He traces the development of the subject in the United States. And while he defends the terminology of restitution in the restatement, he defends that this terminology was never intended to be a literal description of the subject. He cautions that the most serious consequence of the American Law Institute's misnomer is the decline in the professional awareness of the subject. So hopefully Australia will not fall into the same trap by generalizing liability with reference to unconscionability. The historical roots of unjust enrichment also has implications on modern debates about how the subject of unjust enrichment intersects with other private law categories such as contract, equity, property, which are then addressed in part 2 of the collection. So for example, Lucina Ho's chapter begins by addressing the Australian treatment of Moses Macfarlane that we just looked at. She then discusses whether the traditional equitable doctrines can be categorized as part of the law of unjust enrichment. So she looked at, for example, the doctrine of undue influence and the doctrine of known receipt. In relation to the doctrine of undue influence, Lucina argues that the completing plaintiff and defendant-sided theories of undue influence are not mutually exclusive. In other words, the doctrine of undue influence can be concerned with both the plaintiff's impaired consent to the imputed transaction and the defendant's reprehensive use of his influence to exploit the plaintiff and procure her consent. And then using equity's prophylactic technique, she suggests that liability can be imposed to proscribe circumstances in which there is a heightened risk of unacceptable influence as opposed to actual wrongdoing. I have some reservations about her position that undue influence can be a ground for both restitution of unjust enrichment and relief for wrongs for 2 reasons. First, I think equity's prophylaxis is generally invoked in the context of explaining fiduciary duties of trustees. And in that context, where equity's prophylaxis guards against the risk of the fiduciary misperforming, breach of fiduciary duty is treated as a wrong, even though there may not be actual wrongdoing. So if we follow this logic, if the basis of liability for undue influence is prophylaxis, then does it not follow that undue influence is based on wrongdoing and not unjust enrichment? Besides, I think unjust enrichment cannot fully reflect the nature of undue influence. If we focus on the plaintiff's impaired consent as an unjust factor, this may ignore the interrelational nature and structure of an undue influence claim. So I think one should be slowed to generalize from mistake cases which involve unintended transfer of value to undue influence cases which involve intended but involuntary transfer of value. But other than this, I think Lucina also addresses known receipt, mistake, tracing, and equity in her chapter. And then in addition to these equitable doctrines, we also know that the Chancery has granted restitutionary relief in other cases such as fraud, misrep, and then the Chancery also has allowed other restitutionary relief such as account, rescission, etc. So on the whole, I'd agree with Lucina's perceptive analysis that a lot of work will need to be done to avoid the difficulties and dangers of assimilating these equitable rules as part of the law of unjust enrichment in the name of doctrinal coherence. And then the relationship between property and unjust enrichment is also addressed in part 2 of the collection. And then it is also further examined in the context of remedies in the last part of the collection. So I turn to the last part of the collection on remedies. So the big question that we have to ask here is when and why should proprietary restitution be available? So Timothy Loud and Rachel Liu offered a very succinct and helpful overview of the difficulties relating to proprietary restitution, especially after the English decisions in Mellanow and Engelf and Bailey. So they focus on 2 possible approaches to the understanding of the availability of proprietary restitution as an exceptional remedy. So the first identifies the additional reasons that justify the award of proprietary restitution. All right, so this is the first one. And examples of these additional reasons include, for example, the defendant's insolvency or the defendant's conscience being affected, but both of which were rejected by Lord Sumption in the recent case of Engelf as relevant considerations for imposing the trust. The second approach that they mentioned is one that suggests that no additional reasons is required and is based on Chambers' distinction between enrichment by value and enrichment by rights. Specific enrichment means that if the defendant is enriched by the receipt of rights, then he has to give up those rights, and thus proprietary restitution would follow, requiring the defendant to give back that particular right. And conversely, if the defendant is enriched by the receipt of value, then pecuniary restitution follows. Timothy and Rachel acknowledged that the debate remains controversial, notwithstanding the angle of decision. And I offered only a few further points to be considered in this debate. So Chambers' view would need, as they recognize, to be supplemented by a refined understanding of the nature of beneficiaries' interest in a trust, namely that the trust is an obligation to hold the right for another, or it is a duty not to use the specific rights for one's own benefit. So for example, in the case of mistaken payment, the recipient's duty to retransfer the enrichment by right to the payor is a trust for the payor. So while this view of the beneficiary's right under the trust is gaining ground, it remains to be seen whether it will receive judicial recognition. In any case, to say that the duty to retransfer the specific right as a trust for the payor does not tell us why a trust or a constructive trust has to arise in the first place. I think it may be better if we do not proceed on the basis that proprietary restitution and constructive trust must go hand in hand, but instead confront the question of why specific restitution of the enrichment, whether enrichment by value or enrichment by rights, must be mandated. So those reasons may pertain to the nature of the original asset, to the adequacy of monetary remedies, etc. And I think besides, we need to bear in mind that the trust is only one, albeit most common mechanism of effecting proprietary restitution. Proprietary restitution can also take the form of a security claim, but Chambers' view doesn't seem to accommodate these other mechanisms and does not explain why the duty to retransfer the specific right is, for example, an equitable lien for the plaintiff. And well, I think my time is almost up, but just say a few quick words about the other chapter contained in the remedies part. So Katie Barnett addresses the elided remedial concepts of restitution, compensation, and disgorgement, and shows how the confusion is played out in the classifications of reasonable fee awards for breach of negative covenants in the recent cases of One Step and Turf Club. I think Barnett offers a very powerful critique of the overly broad use of compensation to cover a range of cases, and then she presents a very powerful disgorgement analysis focusing on the factual profit received by the plaintiff. I think that's a very, very powerful analysis, but I would also like the chapter to consider a little bit more of the possibility of a restitutionary analysis, particularly in light of what Lord Reed said in One Step, that we might need to focus on the defendant's gain. So would this give some room for a restitutionary analysis focusing on the defendant's gain? Because Lord Reed said one should not be allowed to benefit from his wrong. So yeah, I think my time is up. And then to sum up very, very briefly, I think all the chapters are very, very thought-provoking. And I know that some of the issues and themes that are discussed in this collection will continue to be debated in this conference in these 2 days. And I look forward to the very interesting discussions and exchange with all of you. Thank you very much. And over to you, Michael.
Yes, thank you, Michael. Michael, if we have problems with you, we'll let you know, and you can switch just your video off.
Thank you very much, Elise, and thank you and good afternoon, everyone. It's a pleasure to be invited to speak today and to be involved in this conference. And can I express my gratitude to the conveners, Elise and Michael. I, like Felicity has said, was delighted to receive a copy of the handbook, which was prepared by Elise, Kit and Simone, and very much enjoyed dipping into the various chapters and parts of the book before presenting to you today. It really is an excellent and very welcome contribution to the law of unjust enrichment and restitution. I feel it sits somewhere between a textbook on the one hand and a fresh shrift on the other, combining the benefits of both. On the one hand, it has the benefit of a coherent, well laid out structure, familiar as all of us will be with the law of unjust enrichment, starting with aspects of unjust enrichment, the defences of unjust enrichment, and the philosophical underpinnings of unjust enrichment. So it has that excellent structure to the book. But unlike a textbook, it also has the additional benefit of each of the chapters going into considerable thought-provoking detail about the particular aspects of those chapters. I might just now turn to stop my video to see if that improves the connection, as I understand that there might be some difficulty in hearing me, and we'll see if that improves things. Particularly focused on was the part relating to defences toward the back of the book. They are, as Graham Virgo points out in his chapter, the Cinderella of unjust enrichment. They're often not the focus of interest, particularly by academics who are more interested in the interstices of the cause of action, where all the true action is going on. But as Graham says, and I agree, defences are both vitally interesting and important areas for research and discussion, and clearly in practice as well. As Felicity said in her introduction, the book in relation to defences has a single part with 3 chapters. There's a contribution by Graham Virgo, a contribution by Ross Grantham, and a chapter by Thomas Krebs. Graham's chapter concerns the taxonomy of defences, and I'm going to return to that in more detail in a moment. Ross's chapter looks at change of position, estoppel, and the defence of good consideration. But his chapter is primarily focused on change of position and the elements of the defence, which we know about, being detriment, causation, and good faith, and the rationale for the defence, then examining whether each of the elements just referred to are consistent with or support the defence's rationale. Next, Thomas's chapter brings a welcome comparative law perspective with an analysis of the defence of disenrichment under the German Civil Code. A focus of this chapter is on the breadth of the defence under the German Civil Code, which in practice appears to operate far more widely than its common law cousin, and on rational attempts to find an appropriate boundary to its operation. Having regard to the constraints of time today, however, I just want to return briefly to Graham Virgo's chapter on taxonomy and say a few things about that. Can I say at the outset that I found Graham's contribution stimulating and thought-provoking, as all of his writing is. But I do have a question in my mind whether his analysis met the perhaps difficult goal that he set for himself, or put another way, whether in Graham's own exploration of the goal that he set out to meet, he found that the objective that he started with was not able to be met. Let me explain what I mean. Graham's chapter starts with the objective of identifying a taxonomy of restitutionary defences. He rightly, in my view, states that understanding defences helps us better understand the law of restitution, the reasons for recovery in a claim for unjust enrichment. His thesis in the chapter is that we need a taxonomy to aid that ambition. Graham then presents two forms of categorization. The first of those is what he describes as the reasons for recognizing defences. And he splits those into two further categories. On the one hand, he refers to what he describes as interpersonal justice as being an explanation for defences to claims in unjust enrichment. And really what he's referring to here in relation to interpersonal justice is the notion of corrective justice, which we're familiar with through the writings of Ernest Weinreb. That is, we're talking about the respecting the autonomy of defendants, and that, for example, a change of position defence is at its heart concerned with respecting the autonomy of a defendant in the security of a defendant's receipt of money in good faith. The second aspect is that he identifies a reason for recognising defences as what he describes as external justice, and he gives four types of external justice which might be said to explain defences to claims in unjust enrichment. The first, he says, may be the security of receipt. The second may be statutory exceptions. For example, the operation of defences to claims in unjust enrichment, which apply to the revenue in order to prevent massive amounts of money to have to be repaid by public authorities after mistakes. A third form of external justice he refers to is the claimant's conduct, where he identifies reasons why the conduct of the claimant may be relevant to a defence. And the final aspect of external justice is the importance of finality. And he has here in mind a limitations defence in order to, of course, protect a recipient of funds from ongoing claims in years in the future. So that's the first form of taxonomy or categorization that he provides. As I say, interpersonal justice on the one hand, that is the justice as between two parties to a transaction, and then external justice, so reasons external to the transaction which might justify a defence. The second taxonomical divide that he presents is through the lens of the principles underpinning the defences. And he here offers four dichotomies. On the one hand, he refers to defences that might go directly to the question of enrichment versus defences which are really addressed to the question of the unjust factors. The second of the four dichotomies is a defence depending on whether the claim is private or public in nature. The third is whether the defences are what he describes as rule-based or discretionary. And the fourth is whether the claim is personal or proprietary in nature. Graham then seeks to apply this analysis with the two forms of categorisation I've just referred to. On the one hand, reasons for recognising defences, and on the other, the principles underlining defences, to analysis of the known defences to claims in unjust enrichment and possible defences to claims in unjust enrichment, such as change of position, estoppel, ministerial receipt, illegality, passing on, and subjective devaluation. To me, I felt this might be where the objective of the taxonomy ran into difficulty. I wasn't sure that the taxonomical categories that Graham identified really assisted our understanding or illuminated the defences in a way which helped to better understand the cause of action of unjust enrichment more generally. It perhaps pointed to something that Felicity adverted to when she was speaking earlier about whether unjust enrichment is really just a coherent organising category on the one hand, or just a family of individual distinct causes of action, and that family of distinct causes of action may have its own particular defences which apply to those causes of action. That said, I did think that Graham made some very interesting observations and points about defences to unjust enrichment claims. For example, Graham drew attention to the difference between a response which is properly characterised as a defence and a response which is better understood as either denial of the element of a cause of action or a bar to a claim. I confronted this quandary in my own research on the defence of passing on, which also speaks to the question of whether an enrichment comes at the expense of a plaintiff or not. I'll explain what I mean. When you've got a defence such as the defence of passing on, is what we're saying there that there has been truly an enrichment at the expense of the plaintiff, or are we saying that there is something else going on here? What that means is that you have to examine what the words at the expense of, or what that issue is referring to. Are we talking about the plaintiff's immediate expense? Has the enrichment come at the plaintiff's immediate expense? Or are we talking about the enrichment having come at the plaintiff's ultimate expense after the plaintiff has passed on and recouped the value of the transfer to the defendant? This kind of thinking raises an important question because it affects issues about burden of proof, which have important legal and forensic effects in cases, and also raises an issue about when a limitation period starts to run. Of course, the limitation period commences when the cause of action accrues, not when a defence may or may not be available. In conclusion, I found Graham's contribution to be very engaging and thought-provoking, as I did each of the chapters in this part concerning defences. I feel like his contribution is an important initial contribution, which will have hopefully spawned further research and attention into the operation, scope and rationale of the defences. But I'm not sure, as I say, that it ultimately achieves the objective of, for example, the taxonomical categorisation that Peter Burke's created in his analysis in Introduction to Restitution. I think what Graham has achieved is a useful attempt to better understand the underlying rationale and purposes of the defences to claims in unjust enrichment, without necessarily succeeding in finding a way to pigeonhole or better identify how those defences should be categorised. That said, these contributions are, as Felicity has already said as well, important to the ongoing understanding and debate about the law of unjust enrichment. And I enjoyed very much dipping back into this area and seeing what I felt like was an old friend who I hadn't seen for many years. So I welcome this opportunity, and I thank Elise and Michael again for the opportunity to participate. Thank you.